During divorce, when the court is considering issues of custody, guardianship, or access to the child, the court will look at the best interest of the child. Meaning, in order for the court to decide who will be taking care of the children, or who will be the guardian of the children, or who will be allowed to have access to the children, the court will look at what are the best interests of the child. Now, in considering what the best interest of the child is, the court will look at the following factors: the child's age, maturity and stage of development, the child's sex, the child's background, and any other relevant characteristics of the child. The court will also look at the child's physical and emotional security and his or her intellectual, emotional, and social and cultural development. The court will look at the views or opinions expressed by the child with due regard to the child's age, maturity, and stage of development, meaning the views and opinions of the child will be considered considering their age. So meaning that their views and opinions will also be filtered and looked at carefully depending on the age of the child. The rights of the child to know and be cared for by both parents unless his or her rights are persistently abused by either or both parents, or continued contact with either parents or both parents would be detrimental to the child's well-being. So meaning the court will also consider that it's important for this child to have both parents caring for them, unless otherwise the court finds that it's not good to allow that, or despite that right for the child, there is abuse perhaps coming from one of the parents. The court will look at the nature of the personal relationship between the child and other significant persons in the child's life, including each of the child's parents, any relevant family member, any other caregiver of the child, or any other relevant person, such as maybe their friends at school. So if custody is granted and they might lose certain basic and important relationships for their well-being, then the court will also consider that. The court will also consider the attitude of each of the child's parents towards the child and towards the exercise of parental responsibilities and rights in respect of the child. So, depending on how each parent has been to this child, whether they have been responsible, whether they have been abusive, the court will also consider that relationship between the child and each parent. The court will look at the capacity of the parents or any specific parent or of any other caregiver or person to provide for the needs of the child, including emotional and intellectual needs. So it's not just the capacity to provide financially, but also the capacity to provide intellectual and emotional support. Now, the court will also look at the desirability of keeping siblings together. So if these kids might not be able to function without each other, for example, if they are siblings or they are 3 or 4 or 2 and they are unable to be separated, the court will also look at that. The court will also look at the likely effect on the child of any change in the child's circumstances, including the likely effect on the child of any separation from both or either of the parents, or any brother or sister or other child or any other caregiver or person with whom the child has been living. So they will also look at whether the child would want to separate from, caregivers or their brothers and sisters, or just any separation consideration, basically. The court will look at the practical difficulty and expense of a child having contact with the parents or any specific parent, and whether that difficulty or expense will substantially after the child's right to maintain personal relations and direct contact with the parents or any specific parent on a regular basis. For example, the child is disabled and has specific needs, and there's only one specific parent that can actually provide for those kinds of needs. So the court will look at the practical difficulty or expenses of the child. The court will also look at the need for the child to maintain a connection with his or her family, extended family, and culture or tradition. If this child, for example, will be taken out of the country, for example, and again, it depends on the circumstances, and they might be deprived of their access to their parents, their extended family, or their tradition, or anything that is important for the well-being of the child, the court might also or will consider that. The court will also consider any disability that the child may have. So depending on where you stay, maybe the other parent has access to disability facilities. They have access to a school that allows them to actually go to school. Maybe they are visually impaired and there's no visually impaired. There's no school for people with visual disability or living with visual disability. Then the court can also consider that. Any chronic illnesses from which the child may suffer. So if the child has any chronic illnesses, the court will also look at that in consideration of the custody. The need for the child to be brought up within a stable family environment, and where this is not possible, in an environment resembling as close as possible a caring family environment. So if one of the spouses is, for example, in a stable family setup, and the other one is not in a stable family setup, the court will also consider and might consider that the child actually lives in the best preferred for the interest of the child. The court will also look at the need to protect the child from any physical or psychological harm that may be caused by subjecting the child to maltreatment, abuse, neglect, exposing the child to maltreatment, abuse, degradation, ill treatment, violation, harmful behavior. For example, if this child might end up in a household where people fight, where people drink alcohol, get drunk, and end up beating each other and insulting each other, the court will also look at those factors. The court will look at the need to avoid or minimize further legal or administrative proceedings in relation to the child. So this means that the court will also try and make decisions in respect of custody that will also avoid too much legal proceedings, meaning that a decision that will not bring these parents back to court anymore, or that will actually minimize the chances of these parents constantly going to court and seeking to have access to their child. The court will also look at the parent's ability to support the child financially. And lastly, the court will look at any other factors that they see or deem necessary for consideration in the granting of custody, guardianship, or access to this child. So meaning that the list that is listed in the Child's Protection Act are not exhaustive. So the court still has the discretion to consider any other factors. Thank you.